youth power.
Yes, Giri.
Wait, please, Your Lord.
Yes, you are appearing for.
Lord, I beg to appear in the list of cases, my Lord, where different counsel are appearing. There are two writ petitions, my Lord, where I appear
For the petitioner?
for the petition. Lord, I beg to appear in writ petition number 25 of 2016.
25 of
2016. And then writ petition number 1193 of 2017.
25 of 2016.
16. Yes.
The Act came only in
It
2017.
was amended.
You have subsequently amended it.
Yes. Then, my Lord, there is anyway
1193 of
2017. That, my Lord, squarely challenges you.
70. Okay.
Yes.
So both are in Tamil Nadu. You are in Tamil Nadu.
Yes, yes. I am only in that. I am only in the Jellikattu.
So, you see, the arguments have been fairly elaborately addressed by Divan. You
Lord, I will not-
tell you that, that just need not repeat
No, no.
whatever is there. You can adopt the.
If your Lordships feel that I am repeating
No, no,
anything,
no, no.
Lordships may
No,
want,
no,
I'll immediately stop.
Correct. Need to go to Karnataka and also Maharashtra.
Lord, I am aware of it.
We just want to tell you that.
I'll not
if it's possible. So that.
Lord, it's only 15 minutes to lunch. I'll probably take half an hour to 45 minutes, not really.
Let us see, I mean, any new argument is there? Or?
Lordships may see whether there is anything.
Yes.
If there is nothing new, Lordships may cut me short.
we don't want to cut you short. It is not possible that in return, after the reply comes forward, you get clarity.
Lords, let me do it now because a reply might be necessary once they do. They may have to reply to something which I argue now. They may have to. I believe they have to.
All right, go ahead.
Master.
Lord, just the basics of the contours of what I, my Lord, wish to submit with respect. The correctness of Nagaraj or the order passed, my Lord, in the review petition is really not one of the issues that come up for consideration.
Why files are not?
Correctness of the finding, sorry.
Files क्यों नहीं दे रहे?
5-0.
WPC 25 of 2016 and WPC 1190 of 2017.
I think it has been. All right, then Lordships may kindly confine to 1193 of 2017. That is enough. I thought it was amended the earlier one, but your Lordships may confine to 1193 of 2017. That contains a frontal challenge to this. The earlier 2016, your Lordships are right. Lordships may ignore that.
So 1193.
Look, I had also prepared on the basis
Not
of
this,
the
not this.
2017 petition.
Court master, not this.
If your Lordships have. Only the 2017 need to be.
1193. 1193.
1193 is enough. I'm sorry to have trouble.
Yes.
My Lord has to still get the files in.
No, we have not got.
Yeah.
My Lords have got the files.
I have got it.
Yes.
Yeah, tell us what you
My Lords, please note 3 or 4 dates, my Lord, which might turn out to be, my Lord, relevant in developing my speech. Nagaraj, my Lord, the judgment is delivered on 7/5/2014.
7/5/14.
2014. Nagaraj, my Lord, dealt with the competence and virus, my Lord, of the 2009 Tamil Nadu state. Essentially. And it also went into the other issues which cropped up for consideration. Lordships have seen Nagaraj.
Yeah.
My Lord, an application for review was filed by the state in Nagaraj.
Yes.
which was dismissed on 16/11/2016.
Yeah,
My lord, an ordinance which has led to the act in question
yeah,
was promulgated on 21/1/2017.
yeah,
And the impugned act is passed on 31/1/2017, deemed to have come into force from 21/1/2017.
21/1/17. Yeah,
No, my lords, the order in review passed on 16/11/2016 is not a non-speaking order saying that we don't find any grounds to review. The order, my lords, the learned judges will not go into the contention, they appreciate the contentions. And then they reaffirm the findings, my lord, given in the main judgment in Nagaraj. But also come out with certain other findings, my lord, which your lordships have seen. Some of them, my lord, I beg to place before your lordships. Point is, my lord, your lordships have always appreciated the difference between adjudicated facts and legislative facts. Adjudicated facts are facts, my lord, which are placed before the court. And, my lords, this honorable court adjudicates on such facts. They have a relation, my lord, to the parties before the court. Parties are heard on them. Conclusions, my lord, are arrived at on facts, saying that it has been established on facts that such and such is the state of affairs. Those are adjudicated facts falling strictly within the realms, my lord, of an adjudicatory body. And especially so, my lord, they are entitled to a sanctity when the adjudication is done by the highest forum in the land. My lords, the facts which must have persuaded, my lords, the legislature in the earlier instance in 2009 to come out with an act, my lord, are broader. They are legislative facts.
yeah,
My lord, the challenge to the act in question was predicated on several, my lord, aspects,
yeah,
including, my lord, repugnancy under Article 254. That, my lords, that this violates, therefore, the provisions or it is in conflict with the provisions contained in the Central Act.
correct.
That this seems to be the argument of the state seems to be that this practice of Jallikattu is rooted in the culture and heritage of the state, which is peculiar to the state.
Correct.
And therefore, the organization of Jallikattu by itself, the organizing of Jallikattu by itself, cannot be treated as a cruelty. Or the participation of the bulls in the Jallikattu as an event, and all such things which take place, my lord, in seeing that such an event is organized, will not amount to a cruelty
Correct.
within the meaning of the Prevention of Cruelty to Animals Act of 1960.
Yeah.
My lord, the nature of the animals, their essential characteristics, the fact that they are sentient animals, the fact, my lord, that they are unsuited to participate in an event of this nature, the fact that, my lords, that the actual organization of the event cannot keep at bay, my lord, acts which amount to a cruelty, subjecting the animals to unnecessary pain and suffering. My lord, I use the words because those are the words, my lord, which resound from the reading of the act. Is really has been adjudicated upon by the court, and the court says that no, this can't be done. But there is also, my lord, a finding of fact. These are adjudicated facts, my lord, by this honorable court, and it can't go higher than that. There is a reaffirmation of these adjudicated facts, my lord, in the review order. My lord, it's too late in the day, my lord, and I really cannot advance an argument before your lordship that the legislature is not